The idea that right-of-center lawyers would have to join together to defend the rule of law sometimes against people who describe themselves as constitutional conservatives is just really head-spinning to me. It's almost dystopian. And when I think of people wrapping themselves in the Constitution while they are simultaneously doing violence to it, I want to talk about two cases that I think are really emblematic about what is at stake in terms of the independent judiciary, particularly in checking the powers of the executive branch, and also two events that also exemplify that and unfortunately exemplify how things have changed. Our founding fathers enshrined that in the Constitution and spelled it out very eloquently in the Federalist 78. It made very clear from the outset that the independent judiciary was going to be absolutely necessary to make sure we never had a monarchy, we never had an autocratic system of government. That was the American innovation. But it was always accepted that the courts would bind the power of the executive. In the 1940s and 50s, we had two cases that really tested this with incredibly important ramifications. One of the worst decisions in the history of American jurisprudence. The first case was the infamous case of Koramatsu versus the United States, which of course involved an executive order and military orders that led to the incarceration of loyal Japanese American citizens, certainly one of the great stains on our constitutional jurisprudence. Happily, in recent years, it was finally overturned and is no longer good law. Justice Robert Jackson, one of the greatest people ever to serve on the United States Supreme Court, he said, "Much is said of the danger to liberty from the Army program for deporting and detaining these citizens of Japanese extraction. But a judicial construction of the Due Process Clause that will sustain this order is a far more subtle blow to liberty than the promulgation of the order itself. A military order, however unconstitutional, is not apt to last longer than the military emergency. But once a judicial opinion rationalizes such an order to show that it conforms to the Constitution, or rather rationalizes the Constitution to show that the Constitution sanctions such an order, the court for all time has validated the principle, in this case, of racial discrimination in criminal procedure and of transplanting American citizens. The principle then lies about like a loaded weapon, ready for the hand of any authority that can bring forward a plausible claim of an urgent need." Sound familiar? These words were prescient in 1944. 8 years later, also a 6-3 decision, couldn't have been more different. President Harry Truman, conducting the Korean War, was worried about a labor unrest that threatened steel production. He issued an executive order seizing the Youngstown Steel Company, and Youngstown Steel went to court. This time the Supreme Court said no. Even though the president has broad military authority, he does not have the power to seize private property toward the ends to which he wants to put it. Again, Justice Jackson, this time joining the majority, said, "With all its defects, delays, and inconveniences, men have discovered no technique for long preserving free government except that the executive be under the law and that the law be made by parliamentary deliberations. Such institutions may be destined to pass away, but it is the duty of the court to be the last, not the first, to give them up." I think these decisions and these incredible words from Justice Robert Jackson really exemplify why it is that we need courageous courts that will hold the other branches to the boundaries of their constitutional authority. But the idea that the courts cannot arrest the constitutional excesses of the other branches of government should not, in my opinion, be up for debate. The two events I wanted to mention occurred within 20 years of each other as well. I talked to my students to whom I teach con law, and a number of them are here tonight. And I used to talk to them about the 2020 presidential election. And those of you who are old enough to remember that election, remember it came down to a few hundred votes in Florida, these hanging chads. Fast forward 20 years to January 6th, 2021. We did not settle our dispute in the courts of law as a final matter. And I have to say that as an American, I am so deeply embarrassed at what happened that day. Not just the storming of the American Capitol, not just bringing a Confederate flag into our nation's capital, which didn't even happen during the Civil War, and seeing people who professed to be conservatives assaulting police officers. But not only that, incredible pressure being put on the Vice President of the United States to be the first person to prevent the peaceful transfer of power from one administration to the other. This imagery, to me, is very deeply disturbing. But it shows, I think, that the rule of law is very vulnerable. And we have seen examples of that since then. We have seen the words due process appear in quotes repeatedly, as if this concept was created by rogue liberal judges to help illegal immigrants stay in the country. Due process is the most foundational legal principle protecting individual liberty in Western civilization. It dates back to the Magna Carta. It does not deserve to be in quote marks, air quotes, or quotes in op-ed pieces. Most recently, and I know you all know this, but I want to read the exact words because they are so deeply disturbing. A high-ranking administration official said, "The Constitution is clear that the privilege of the writ of habeas corpus can be suspended in a time of invasion. So that's an option we're actively looking at. Look, a lot of it depends on whether the courts do the right thing or not." Regardless of how you read that, one, that they're seriously considering suspending the writ of habeas corpus, or two, that they are using that to intimidate the courts to reach decisions that they favor. Either way, it is really scary stuff. I believe that judges need to play a very important role in defending the independent judiciary. It is a great story to tell. Do judges sometimes screw up? Absolutely. Mea culpa. Do judges sometimes give in to their personal predilections? Too often they do. But overall, there is no judicial system on earth that I would trade for ours. And if you believe in individual liberty, standing up for the rule of law and the independent judiciary, no matter who is attacking it, is an absolute priority. And so, for that reason, it is an honor to be among you, and I would just close with the words, count me in. Thank you very much.